in terms of the victims' rights debate, it's my view, and it has been my view for many, many years, that victims should not only be able to participate in key decisions that affect them, but they should be assisted in making those decisions. And so one of the things that I did do for many of the years as the Commissioner was engage legal counsel. And I think last time I tallied over 200 cases we had in the 10 years I was Commissioner provided some form of either referral to a lawyer or actual legal representation for the victim. And it became so commonplace that there were even requests that came sometimes from the court itself when, or from prosecutors saying, we've got a question here. We feel that it's not our job to influence the victim in terms of the decision. Would it be possible for them to go and get some legal advice? And we've managed to overturn some decisions as well. In one case involving someone with a form of disability, where an assessment was made not to prosecute, and then after review to prosecute only a lesser charge, after provided legal counsel to assist the victim articulate their argument and put it more forcefully to the prosecutor. Another review was done. A decision was made to prosecute the more serious charge, and that was successful, and the perpetrator was found guilty. And that would never have happened if it wasn't for the fact that the victim had counsel to help guide them through that process. We've also had cases where the decision has remained the same. For example, no prosecution or prosecution of a lesser charge, but the victim's been more accepting because they have not only had the right to participate and be consulted on the decision, but they've had someone with whom they can confide and get assistance in their comprehension, their understanding of why that decision was made. I think that in a procedural sense is what victims are seeking. They're seeking just decisions that are fair and equitable in the process by which they're reached.
So in terms of legal counsel, is the main prevention of that happening all the time to do with cost, or do you need permission from the court to enable victims to have legal counsel in the process?
Well, at the moment it's a matter of, some of it's a matter of interpretation. So in the Victims of Crime Act, there are entitlements that victims have for consultation. Also in the Victims of Crime Act, Section 32A says that with approval, an appropriate person can represent the victim and exercise any right or entitlement that a victim has. And an appropriate person includes the Commissioner for Victims' Rights, either in person or through legal counsel, or the victim having their own legal counsel. So utilising the sections read together in conjunction with the authority of the Office of the Commissioner, I just basically, whenever there was a contentious issue, decided to test the law. So an example is that there's a section, forgive me for quoting the sections, but Section 269P of the Criminal Law Consolidation Act, which relates to an application for a revocation or variation of a licence order that applies to a person who is mentally incompetent but been found guilty of the objective elements of the offence. And what it says said in that section back in 2012 is that whenever there's such an application before a court, then certain people can be heard on that application. And the general phrase in that section said an interested person, and that had never been tested. So we decided to test it, and Justice Gray, in 2012 in a case of Steele, Harvey Steele, determined that he could not think of a more interested person than the family who were bereaved by the person the mentally incompetent offender had killed. And so he allowed them not only to make submissions to the court, but also to cross-examine witnesses through legal counsel. And that decision then has been followed in cases such as R.V. Bowen, which is another mentally incompetent offender case, and many others. So much so that there was pressure exerted on the Parliament to clarify the law. And the current Section 269P says that the Commissioner for Victims' Rights has standing and can even apply in his own or her own right for a variation to a licence order.
How did you get that in there?
And well, it took a little bit of advocacy, and we tested that law just before my term ended in July of 2018, and in the case of RV Simper, and the court upheld it. And we were able to, what had happened is that the case had been settled, a licence order had been, and variations to it had been agreed between the prosecution and the defence. But in that agreement, there was a failure, in my view, to take into account some of the concerns of the victim. So I engaged legal counsel, and we lodged an application through me tendering an affidavit to the court to apply for a variation that would take into account the victim's needs. And the court received the application, deferred its or adjourned its decision to allow for negotiation, and then when it came back to court, it accepted the application, heard counsel on the matter, and the variations that the victim had, or victim's family, because someone had been killed, had applied for, and were in their original report that they put in that had been omitted earlier in the proceedings, were all taken into account, and a new order was issued.
Okay.
And we've got other examples as well. We've appointed, well, I appointed legal counsel to assist a victim where there was of a sexual assault, where there was an application for access to her Medicare records. And if you look at a Medicare record, it has a provider number and a provider code for the type of treatment, and it traces your entire history that while you've been under Medicare. So that meant that the accused was getting access to information about this person's circumstances prior to and post the offence.
So they can then cross-examine
and then they could cross-examine on issues
health
there.
issues or whatever.
That's right, that weren't deemed, and we fought the issue and said, well, in its broader sense, this should be protected as is communications. The court ruled against that, but what the court did do is say that for the period of time that the victim was being cross-examined on the information from the Medicare record, legal counsel could remain in the audience of the court, and if the victim wanted to take some advice, then the victim could ask for an adjournment, go and speak to the lawyer, which I think, that's a step in the right direction. We've also done arguments around competency and compellability. So one good example of that is where two brothers are fighting, one brother murders the other, and the mother then is to be subpoenaed by the defence to give evidence and to help favour the son who is now the accused murderer. And of course this puts her in a terrible situation, because then it looks like she's siding with the person who killed her other son. And we were able to give her legal counsel, and through that counsel negotiate an agreed statement of fact about key issues in the relationship between the two brothers that didn't expose her to the probability of secondary victimisation through the ordeal of having to give evidence and therefore be pitted against her own other son who was the victim. And another example, suppression orders. So in the Phil Walsh matter, where Phil Walsh, the football coach, was killed, or the matter that the media call the Hillier murders, that's the young lady and her two children who were murdered out near Gawler. In both those cases, I intervened through legal counsel, and we attained suppression orders to protect the innocent victims from particularly tabloid-style reporting on matters that are, in my view, of no real benefit to the in terms of public interest.
Yes.
The public might be interested in them, but it's not. There's no public interest, which is a fundamentally different thing. And there are a range of other examples where we've provided legal counsel. Now, all of these things have helped make South Australia quite unique, because we are the only jurisdiction in Australia that, through the Office of the Commissioner or through my reading of Section 32A and it's some other sections, such as some of the examples I've given, where we've been able to substantiate in both law but also in practice that victims should not only have a voice but an equitable voice, and as a consequence they should be given voice recognition. That is formal acknowledgement
Yes.
of their view, of their contribution. And I think that's incredible, and in fact it was one of the reasons that I began to be asked to speak internationally, because people around the world were intrigued by this, I'm not sure how you describe it, almost like a social experiment within the legal process of trying to ensure that victims got procedural justice.